Thank you, Vernon. And thank you, Caroline, and for organizing this for the whole New Zealand Centre for Environmental Law. As you know, my name is Justin, for those who don't know me. First time I heard about the ICJ was probably in 1998, probably before some of you were not born, but some were probably born, right? But that was when I was studying in Jamaica law at the University of the West Indies. And, you know, you hear about this ICJ and you learn about these cases. So, I mean, that was just like a remote dream back in the day as a law student. So now, you know, actually being part of the process, you know, we kind of thank God for, you know, seeing that transition to where you are. In July, a month and a half ago, I was in The Hague, and Vernon talked about gasps, I think, you know, and the reaction to the courtroom. I remember on my left I was sitting down next to the delegate from the Council for Bahamas, and my right was St. Lucia. And we were listening to the judgment by the president and the ruling. And every time the president said something, sea level rise, which I'm going to speak about, they would hit me and like, oh, that's what we argued. That's what we argued. The judge got it right. This is what we argued. And I was just like, all right, yeah. So that was going on for about 5 minutes. I was just like, okay, cool down. I really want to like concentrate on the judgment. So there were some gasps and there were some, of course, excitement in the room, especially for small island states. So I'm going to talk about sea level rise, statehood and intergenerational responsibility. So sea level rise, the court said it is unavoidable, right? So no matter what we do now in terms of greenhouse gases emissions, man-made climate change, it's going to happen. So it's unstoppable. So you have, and it's an omnipresent threat. So you have let's talk about the Pacific. So we have Tuvalu, for example, one of the first countries in the world that would lose their territory. That's a given, right? And then you also have Kiribati, which is another low-lying atoll state. And I just wanted to quote what they said in their oral statement. One of their councils, they said, "We want to secure our self-determination and permanent sovereignty over our natural resources." Now, Tuvalu and Kiribati, they are actually, and the Fiji delegate was speaking about that. I don't know if anybody from Fiji is here who could confirm, but they actually have residents who are living in Tuvalu, in Fiji, from Tuvalu and Kiribati, because of climate change, because of sea level rise. So the government has allowed, if you want to call them climate migrants, to actually live now in Fiji. Now that doesn't only affect atoll or small island states in the Pacific. We had Papua New Guinea, who their delegate said that 10 of their islands, and Papua New Guinea is one of the biggest islands in the Pacific, or probably the biggest. We're not talking Australia, that's a whole new ball game, that's a continent. But they said they already lost 10 islands due to sea level rise. So one of the countries I represented was Grenada. And Grenada, we had a video showing that there's an island off Grenada. It's an archipelagic state, sorry. And that island is called Carriacou. And there's one cemetery there where, because of sea level rise, the tombstones are now in the ocean. So we saw pictures, we saw the videos of, imagine having to visit your grandfather or grandmother's grave. You probably have to put on your togs or your trunks, no joke, and probably walk out in the sea. They have actually tombstones in the water. And so that was, we had a witness statement from a resident from Carriacou, and she said, "It is our obligation to respect our elders during their lifetime and even in the afterlife. And the loss of the graves of my ancestors represents a failure on my part to uphold their legacy." So here she is taking this personally, her responsibilities, when it's really climate change, right? So we had all that evidence we displayed before the judge. And I have a favorite artist. He's long passed away now, and he in his 90s. His name is Knut Kalis, and he I thought I'd bring along this book. He was famous for painting mermaids and the waters of the island of Carico. And he said when he was 9 or 10 years old, he actually saw a mermaid. For those who believe in mermaids, I just thought it was, and don't get me wrong, mermaids probably exist. I don't know. But I think it was I wonder what he would think now what his mermaids would think about sea level rise. And maybe it shows also the connection with the people in Grenada with their land, their oceans, and sea level rise and how that's a threat to them. So the grades was like a cultural right that was being portrayed there. So sea level rise has many implications. One of the implications is sovereignty, of course, displacement of populations, as we see with Tuvalu and Kiribati already, territorial integrity, and permanent sovereignty over their natural resources. It's also connected to self-determination. Now, the ICJ, what they ruled with sea level rise was very interesting. And up to now, we are still trying to figure out how those implications would work. Because, okay, under the UN Convention for the Law of the Sea, you have baselines on your coast. And from the baselines is where you measure your maritime borders. So the coastline from your baselines are like a coast. So you have 12 nautical miles will be your territorial sea. A state can claim that. New Zealand, of course, does that. So 12 miles will be your territorial sea. 200 miles will be your exclusive economic zone. And if you don't have, well, you could also claim a continental shelf, which is your natural prolongation of the land. That's where you could explore for oil and gas, natural resources, whatever have you. So you could claim at least up to 200 nautical miles, generally, right? But with sea level, so when you do that, states have to update their charts or list of geographical coordinates to show that this is my maritime boundaries up to 200 miles, more or less, right? Nautical miles. But now with sea level rise, and under the UNCLOS, the United Nations Convention for the Law of the Sea, once you claim that territory, you can't update it. So that's your maritime boundaries. They're published with the UN Secretary General. So with sea level rise now, what's happening is that your maritime, because if there's coastal erosions, then your maritime boundaries are now becoming less and less, right? So for the Pacific Island states, big ocean states, small countries, but very big in terms of maritime boundaries, right? So the smaller the country you are, the smaller island, you could claim a whole lot of maritime boundaries. But now what's happening now is that the court says that states who are losing territory because of sea level rise, your maritime boundaries will freeze. So you don't have to, you're under no obligation to update it. So in other words, if a state is completely underwater, they could still claim that they exist and they still have maritime boundaries. Now that's good for the Pacific, right? Well, not good to the extent because you're losing your territory, but Pacific countries and some Caribbean states argued for that because they wanted to preserve their maritime boundaries, even though they're underwater. They're saying that the land is still there, but it's just that it's underwater, technically. And the court agreed with that argument that you don't have to negotiate your maritime boundaries. You're under no obligation to do that. Right? So it makes room now for what you call a deterritorialized state, where that really means that, and this is actually happening now, where states are claiming, they could claim a state within a state, like what is happening. Well, it's not happening in Fiji, but this is like an argument that's I'm not inventing this. This is probably in a future discussion will happening now, maybe in the next 20 years. So for example, we are here at university, let's say the closest suburb, maybe Mount Eden, Epsom, just calling random names, right? Let's say if 20 years from now, Tuvalu has an agreement with the government of New Zealand that we are going to set up our state because we are totally underwater, we're going to set up our state in Mount Eden. And the government agrees with that. So there'll be a state within a state because the land has disappeared, but we still want to recognize our historic, social, cultural rights. And states are actually talking about that now. And this judgment actually makes it even possible. So what will happen? Do we have to pass a law? Do we have to go to a referendum? Do the people have a choice? Would a government even accept that? Maybe government may say that that's ludicrous. That's like crazy, right? Ludicrous, right? So these are some things, these are issues that we have to grapple with. And as future lawyers or even politicians, these are issues that you'll have to deal with in the Pacific and in the Caribbean. I just want to talk quickly now about intergenerational equity. So each state, this intergenerational equity means that each generation is entitled to inherit a planet or the earth as just as good as, at least as good as that of their previous generations. So in other words, the future generations should inherit a planet that is the same, at least minimum. Could be better, of course, but definitely not worse. And when you speak about future generations, you're not talking about, okay, your 2-year-old son or your 1-year-old daughter. That's a present generation, right? Future generations are someone who's going to be born in 2026. You can even go 20, 30, 40, 50, right? So the argument is, do future generations have rights? That was a big argument. And some states, the global north, US and Europe, some European states were saying that future generations should not have rights. Why? Because human rights are something that you give to human beings. So why should New Zealand, let's say we're in New Zealand, have responsibility or rights or be concerned about someone who's going to be born in 2050? But our argument was that, when I say our, Pacific Caribbean states, we argue this, that future generations should have rights because, one, they did not consent to the climate crisis, and two, they are going to be unduly burdened by the effects of what we do now. So somebody in 2050 will be burdened by what we're actually doing today, right? So from that perspective, we argue that future generations should have rights. And at the beginning, to me, that was a clear-cut argument, because the court has already said in the nuclear weapons case in 1996, almost 30 years ago, they said that nuclear weapons would have an effect on future generations. And then the pulp mills case in 2010, they also spoke about intergenerational equity being part of international environmental law. So for me, the ICJ already pronounced on that. But when we heard the global north, and I think Saudi Arabia was also one, saying that future generations should not be acknowledged, we got a little bit concerned about that. So we had to remind the court about their decisions 30 years ago. And the court actually said in paragraph 1656, and I just wanted to quote that, intergenerational equity is an expression of the idea that the present generations are trustees. And that was a point that we all raised. That was a nudging moment again in the court. Yeah, we said that, of humanity tasked with preserving the dignified living conditions and transmitting them to future generations. And the due regard for the interests of future generations are equitable considerations. So I think that was, court clearly certified or clearly confirmed that states should have, when developing climate policies, we heard Jessica speaking about NDCs, Caroline, and so on, New Zealand, we should have, the government should look at what our impacts would be to someone who is born in 2050, right, for example. To close, I just wanted to compare future generations. I didn't get the time to say this in the court, but because you just had each person had, we had 3 persons speaking, so each person had 10 minutes to speak, which is the length of time I'm speaking to you now. But the intergenerational responsibility is called attitude of gratitude. And I got this, these are not my words, this was from a professor from South Africa. And I was reading that before the court case, and it made sense. Attitude of gratitude, meaning that if, use the example, if you are a student, which most of us are here, or a student of life, if you have graduated already. But if you're a student and you don't have a car and you want to drop somewhere, you'd hitchhike. Anybody ever hitchhiked before? Probably. All right. Student of life, professor. Yeah. So if you're a student, you will hitchhike and you will get a lift. But then when you graduate and you become known in your profession and you could afford a car, when you're driving that car, you have an attitude of gratitude. So if you see another student 20 years later begging for a job, you would more than likely stop for them, right? Because you have that attitude for gratitude. So it's the same thing that we would hope that our future generations will have attitude of gratitude for what they did, what we did for them. So that's how he developed that whole idea of intergenerational equity. So I'll just leave it there, Bunan. I hope I didn't go over my time. Thank you very much.